All right. Good afternoon, everyone. Zama Dlamini from Moses Kotane Institute, and welcome to our Friday visual lecture. As most of you already know, October is Cybersecurity Awareness Month, and as the Moses Kotane Institute, we will be joining the globe by participating on cybersecurity awareness campaigns that are targeting the KwaZulu-Natal province. They will be targeting the internet users from KwaZulu-Natal province with the aim of contributing towards securing the KZN cyberspace. One of many activities that Moses Kotane will be doing this month include virtual lectures on Fridays at 12, and this is one of the series of these lectures. So we would like to encourage the internet users to be cybersecurity savvy, and we will be using various media to do so. So our first speaker of the month is Mr. Ngobeni. He is a senior cybersecurity researcher from the Council for Scientific and Industrial Research, that is CSIR, Pretoria. Sipo holds a master's degree in computer science, focusing on information security and digital forensics. His research work was on wireless networks and in digital forensics. And then his most interestingly research interests include cybersecurity governance. He also likes to look into cybersecurity audits. He also focuses on cybersecurity for awareness, data privacy, protection, security operations, and so forth. So today, Mr. Ngobeni will be clarifying for us if he will be telling us more on the topic, whereby he'll be focusing on the topic that is trying to answer if the current state of affairs in Africa does have any evidence that suggests that we should be worried when it comes to data privacy. Mr. Ngobeni, over to you, sir.
Thank you so much, Zama, and good afternoon to everyone joining virtually and the team at the Moses Kotane Institute. Zama, before I proceed, can you confirm that I'm audible enough?
You're very much audible, sir. Thank you.
Thank you so much. So today, essentially, I'll be talking about data privacy. And thank you, Zama, for the very precious introduction there. This is the content that I will be talking about today. So I'll first give a high-level overview, looking at the spectrum of why do people get hacked, how has it started, and where are we, and the different types of attacks that we've seen, in the past, starting from 1990 up until today. Then we will start to get into the gist of what I will be talking about today, which is data protection, to define what that is, so that we all of us together with the attendees virtually to understand what data protection is. Then we'll move to the current laws, pertaining to data protection across Africa. Then we zoom to our own specific, data privacy law or data protection, some interchangeable terms that people use, to refer to this act, as you can see, even with some of the global acts. After that, we then going to look at some of the most prominent attacks that we've seen in South Africa. Then that's where we're going to start to answer the question to say, should we really get worried about data protection in South Africa? And then sort of my closing type of talk will be centered around what are some of the efforts that South Africa has actually put in place, especially from a government perspective, looking at the various national response structures that emanate from the National Cybersecurity Policy Framework as an effort to thwart the rapid increase of these cybersecurity attacks. Now, the issue of cybersecurity comes, I mean, a very long way, you know. I think people get attacked for different reasons by different, you know, actors. For instance, as you can see on the horizontal, the top part of my screen there, you know, you find what you call script kiddies. You know, these are people, I like to call them novice when I talk to my friends, you know, that just have interest for a mere fact that you, as Zama Dlamini, you are on the internet, and probably you possess, you know, a vulnerability which could be, you know, a typical security setting in your a Facebook account, you know, and they will try, you know, to test or to ping if they can actually be able to penetrate in a Facebook account. So those are sort of unsophisticated attackers, you know. I can call it, you know, I like to call it babies, but hey, they can cause a havoc. Then we have got what you call sophisticated. These are actual attackers. You know, the purpose of these guys, it's actually, you know, first of all, obviously, they see that you have a vulnerability, and you, most importantly, you have information, whether in your organization or as an individual, that possesses value, you know. And their purpose is sort of to try and disrupt you as an individual or your business. And we have what we call corporate espionage, or the malicious insiders. Sometimes they call them insider attacks. You know, so this can be typically an employee within your business or an organization, you know, that try to steal financial information. You know, it can be credit card related type of records. It can be personal identifiable information, you know, and essentially share it with your competitors, you know, so that they can eventually come back and target the business. Then we have what we call organized crimes. You know, this sort of starts to be, you know, very, very interesting. They come in a form of networks. You know, they have got capabilities to steal your IP within the business, because these type of threats, they are very persistent. You know, they look for value, they look for selling your information into the black market, or even blackmail you, you know, or even hold you ransom. And I think as I proceed with my presentation, you will see some of the most recent ransomware attacks that we have experienced as a country. Then we have got what we call state-sponsored attacks or the advanced persistent threat. You know, these are sort of, you find a typical example of China, you know, for instance, fighting with Russia, you know, for the purpose of inflicting damage, you know, or they see the other country as their competitor, either in mineral resources, you know, or for whatever reason, you know. So as you can see there, that there's a lot of these examples, types of sophisticated attacks that we've seen moving from 1990 up until 2021. But what I like, or what I think is most prevalent, is the criminal networks, as well as the advanced persistent threats. I think this is what we've observed as South Africa in the recent past. So getting to the topic of the day, really, those attacks that I've shown, you find that in some instances, their purpose is just to steal information through ransomware, like I think most of us have seen. And then whether you pay or you don't pay, there's a chances that they can take that information and then dump it, you know, in the public, and then exposing your personal information. So that's how more or less the issue of data protection, it becomes very, very important in the context of the business. You know, you need to ensure that you have got processes that you implement in place in order to safeguard important information, you know, in your business, to prevent them from being corrupted or compromised, or even losing them, you know, to insider attacks within your business. So that's essentially what a data protection is. We're trying to protect the assets, or the information assets within the business, so that they don't fall into the hands of victim or wrong people. Now, these terms sometimes gets used interchangeable, data privacy or information privacy, but essentially what it means is that as a citizen of a country, you need to understand, who collects your personal information. Did you give consent to that personal information that they have? What is it that actually the organization that holds your personal information, which will describe as I proceed in this talk, what personal information is and why is it valuable in the hands of the cyber criminals? And then these three terms, the data protection laws or the acts, the bills and so forth, we'll see in different countries, they refer to these using different terminologies. But these acts, there's a concerted effort, I think the most popular one is GDPR, General Data Protection Regulation. That's a European regulation. We'll get into it as well. They're being set up, as a mechanism to ensure that the rights to privacy for individual is actually protected. So we essentially looked at, and it's public information. It's not my information. Everyone can essentially go and actually look at it. It's presented very nicely there. If you click on each of those countries, it actually tells you the state. But it sort of rates these countries in terms of how have they progressed in terms of number one, drafting that bill or getting it enacted or passed within the legal system within that particular country. So the radar, you can see this is a global map, but our interest really it's in the part where we're looking at South Africa. I'm sure all of us, we can see where Africa is in that map. And you can see where there is, I think, the gray color. It tells you that there's absolutely nothing, no law regarding data protection in those particular countries, which really raises for me a big question. Like if you can check, I've listed about 20 countries that have these regulations, the data protection regulation. That tells you what is the current state of affairs in South Africa when it comes to these laws. So I think we have about 50-something% countries. Well, someone can argue and say, look, we are really trying. Most of the countries, they are not even belonging to the developing countries in South Africa. They are not like your Egypt, your Morocco, South Africa, Nigeria, and so forth. Those are the fast developing countries. I think your Kenya and so forth. But really, if you check the ones that are highlighted that I've italicized, the Cape Verde, in terms of maturity, I think it's moderate. It's more or less similar to South Africa. We have got Ghana. So I think in essence, the moderate there might essentially mean that at least at minimum, they have the act or they have the law in data protection. Now, the issue of compliance, it's something else. They've not really made so much concerted effort in terms of making the law, making sure that organizations comply into that particular law. But I like where we are as South Africa as well. If you can check there, the bottom, we're sitting in the bottom, and I think the country that is inside South Africa, I think is Botswana or Lesotho, so if I'm not mistaken, it's moderate, meaning that our data privacy law, which is the POPIA Act, has slightly matured. We have got the Information Regulator, which is an independent body responsible for that act. We'll talk about a little more into detail after this slide. But the issue of compliance as well, it's something that I strongly believe we're still battling with. But as time progresses, I think we're eventually going to win, because there are very, very strict laws or clauses within the act that stipulates that non-conformance to that act can essentially result in a bad situation as a company. Yeah, to give my overall judgment here, I think really we are making some effort as the continent, but there's still more work really to be done. Now, let's look at this POPIA Act that was recently signed into law, but obviously it's not a new act. This Protection of Personal Information Act It was signed by the president, I think, in 2020 last year, but obviously it has since been there from, I think, maybe that's a mistake, 2013 or so, if I'm not mistaken. Yeah, it's a very interesting regulations, as a country, all of us, we need to make sure that we understand what is inside that act. And as a CSR, obviously, we've started working with a lot of, institutions, having some discussions around the issues of the POPIA Act. So the Information Regulator, it's an independent body that reports directly to, I think, the Parliament or the Cabinet. Belongs to Department of Justice and Constitutional Development. That it's set up specifically to look for two acts, the POPIA Act as well as the Promotion of Access to Information Act. And they're chaired by advocates Pensi Tlakula. I've listened to her on various number of occasions, some of them similar to this. I think for me, really, and her team, they're doing some quite interesting work there. So let's get to the rationale of why this POPIA Act actually is there, So I think some of us, who like to read the Constitution, I think Chapter 2 talks about the Bill of Rights within the Constitution. So it says every citizen, will have the right to privacy. So when they say you have got a right to privacy, so essentially what it means is that it means the organizations that processes your personal information, it gives you the rights to ensure that they don't do that in a way that is unlawful collection of your PII information, the retention, dissemination, and use of your personal information, So the state must respect, protect, and promote and fulfill that right as it's set in the Constitution, which is Chapter 2 of the Constitution, which is Bill of Rights. So that's where this act actually came about. It tried to sort of dissect or expand from the Bill of Rights as it's set within the Constitution. Now, and we need to bear in mind that even though this Constitution, says companies must not collect, retain, use our PII information in an unlawful way, there's still a couple of things that we need to balance. Remember, we are living in a state where people need to sort of make economic sort of impact for them to sustain their selves as well as social progress, And within that framework, the information society requires the removal of unnecessary impediments on the flow of information, including personal information. So there's that balance that we always need to maintain as a business, and vis-a-vis the law, to say this is what the law says, but we are definitely, as business or individual, going to process this PII information, but we need to make sure we make that balance. And most importantly, this regulation does not work in isolation. We need to make sure as we read it or interpret it, we also look at other international standards. Some of them, they are local, so I've realized recently that you cannot read the POPIA Act in isolation. There's other acts as well that talks to what we call rights to protecting personal information. I've read the Consumer Protection Act. There's issues of personal information there, the Protection of Access to Information Act as well. So it's a very interesting act, but we'll go slightly into detail and look at some key definition, because the act says organizations that process personal information needs to make sure that they do so in a lawful way, in a way that is they collect the information in minimality. They need to obtain consent from data subject. There must be justification, and the data subject need to be able to object to whatever that they are not comfortable with. So what essentially processing means? Processing means any operation or an activity or any set of operations, whether or not by automatic means concerning personal information. So essentially, we're talking about a company where they're using your information, collecting your personal information, recording personal information. I know Zama is recording myself here. Perhaps I can pose a question to say, how is she going to make sure that the record that she has kept about Sipongo Beni doing the keynote presentation, you're going to store it in a manner in which is going to protect my voice, because if you link my voice, you link my name and surname, that's typically a personal information. People who know, they can easily identify SIPO uniquely. The dissemination, is she going to take this video, disseminate it to people that I did not consent to? Is she going to do some modification on this video, for the purpose that I'm sort of not aware of? So that's essentially what processing of personal information actually means. It must be done in a way that is lawful. It must make sure that if you collect personal information, it's as minimal as possible. First of all, the data subject needs to consent into that, and it must make sure that it's minimal as possible. So one of when I listened to Advocate Penzi in one of the talks recently, there's a big drive, to sort of engage the people within the estates, across South Africa, to say, hey, look, when a visitor comes to your complex, you take their driver's license, for instance, most of them. They then, most of the time, carrying what we call rugged phones, which they use to scan the license disc in your car, all right? They take the registration number. Some of them, they will print, a slip of some sort that has the pin that you can punch so that you can gain access. Then there's an argument to say that is collecting too much personal information for that particular purpose of just someone getting a passing to visit someone in an estate. So it's a big drive, and they're just not thumb-sucking or taking this thing on top of their heads. It's just because of that word minimality. So when you collect personal information, it must be as minimal as possible. What is personal information? I think I've been saying personal information, but according to the Act, the personal information refers to an identifiable, living and a natural person. An example of this will be your race, your gender, sex, pregnancy, and so forth. The biometric information constitute your personal information. The views or opinions of Julius Malema, for instance, will constitute personal information. But what I find to be most interesting is that if you say Zama Dlamini, for instance, one can ask, is that a personal identifiable enough to be considered as PII? The answer is definitely no, because if you go to Google and search Zama Dlamini, chances are, and I know a lot of them, you will come with probably 1,000. Then we cannot say Zama Dlamini is personal information. But the minute you say Zama Dlamini, Moses Kotane Institute, then that is personal identifiable enough. Chances are, if we were to get to MKI and ask how many Zama Dlamins we have here, chances are she's the only Zama Dlamini, or probably there will be 2. If there are 2, then you probably need to add another attribute, where you can then pinpoint the exact person. Then that becomes personal information. Hope I'm clear there. Then the Act, or the Popeye Act, talks about what we call special personal information. So these are sort of a religious type of belief, philosophical belief, your race, your ethnic origin, the type of political party, that you support, your health, your sexual orientation, your biometric information, criminal information, and personal information of children under the age of 18. So this is what the Act categorizes or classifies them under what you call special personal information. So obviously you will know that there's what we call data at rest. I think some of the people attending virtually here, especially if they are within the cybersecurity discipline, they will understand what this data at rest essentially means. So this is any information which is not in the process of being transferred by any physical or electronic means. This could include, your hard copies, documentation that are stored in an archive or filing system. There are even other acts that really talks about this, on how do you handle, how do you transport, how do you collect, how do you distract such destruction of such, data at rest. So the POPIA Act as well has some what we call clauses within the Act that stipulates on how data at rest should be collected, especially if it contains what we call PII information. What I like mostly about the Act, even though it has, I think, 12 chapters or so, one of the chapters, the longest chapters, and I think the advocate pens as well, when it talks about this act, it says this is the most prominent chapter within the act, which is that talks about the 8th condition of processing personal information. So as a business, you really need to make sure that one way or the other, these 8 conditions are actually implemented within your business. So I don't want to go into detail, but some of the most important things that are here is to ensure that as a business, number one, you have appointed what you call the information officers within your business. So the information officer in this context can be a CEO, and he can delegate that responsibility to what we call the deputy information officers. After appointing them, the next step is to ensure that they are being registered with the information regulator. And I think one of the conditions as well, it talks about what we call information quality. How can we make sure, for instance, that the ID number that someone produces, it's number one, it's complete, and people cannot just manipulate or change it just like that. The rights to data subject, have you considered as a business to ensure that before you collect, the PII of your employees, have you explained to them so that they can understand what are their rights with respect to the personal information that you're collecting about them? Another chapter, chapter 8, talks about direct marketing. I think most of us will say we are victim of this, where you find some these days, specifically for myself, I've received a lot of what you call calls, electronic calls. When you pick up, sometimes they drop them, sometimes they just sell some stuff to me. And I've never really subscribed to all these things, So the Act sets very clear, sanctions with regards to this. Companies, especially those who are doing electronic marketing, they need to make sure that they take that chapter very, very seriously, because data subject needs to make sure that they provide that consent before you can do what you call electronic marketing, to them. Transborder issues. So this is an event whereby you find that a company in South Africa, will do some business with a company probably in Malawi also, because the POPIA Act, its jurisdiction, it's only within South Africa. It's an act that is applicable in South Africa as compared to GDPR, which is a European regulations. And depending on what is set there, chances are you'll find that everyone, one way or the other, you need to comply to that. So there are regulations, there are clauses within the Act that talks about transborder information flows. If a company in Zimbabwe does a business with a company, or if a company in South Africa were to transport Zama Dlamini PII information to Zimbabwe, that third party has sort of a prerogative to make sure that they comply to the clauses that are set out with regards to transporter information flows. What I like the most is the offenses, the penalties and the fines as it's set out in the POPIA Act, So failure to comply to these regulations, the information regulator can issue a a sentence not exceeding 10 years imprisonment. Can you imagine? I've really never thought about this, but hey, it is there, and I'm looking to see it forward, whereby some of these companies that fail to protect our personal information, get charged up to those sentences, or you can be charged up to the value of not exceeding 10 million by failing to comply to the act. I think I've heard the word GDPR as I was speaking. So it's one of the European regulations, very much similar. So I can say the POPIA Act, it is, in my view, a subset, of the POPIA Act, even though of the GDPR, even though some of the clauses in the POPIA Act are not really explained into detail. So I'll just give a typical example of how this GDPR work. So think of Zama Dlamini having a website, and I know she likes online shopping, having a website in South Africa. This website, she obviously, maybe she's selling clothes, just lack of, better words there. And then you find that some of Zama Dlamini's customers within that website are European citizens, right? So by virtue of that, that means one way or the other, a European citizen will come provide their name, their surname, maybe their credit-related information to purchase that particular shirt or belt in Zama's online shop. Now, what GDPR says is that everyone that processes records of people within the European Union, they actually need to protect. So by virtue of that, that means one way or the other, Zama's Dlamini online shop needs to make sure that they don't only focus on the clauses as it said in the POPIA Act in terms of protecting PII for his electronic a website, so they also need to take cognizance of some of the clauses as set within the GDPR. So this is just the comparison to see what is essentially different. So just to give an example, I think number 3, the roles and definitions, so you'll find the POPIA Act calls that a responsible party, but the GDPR says it's a PII controller, and operators. PII, a controller, and PII processors. Those just similar, term that are used in, different pieces of legislation, but they really mean the same thing, right? The fines and the penalties, the POPIA Act imposes about 10 million, not more than 10 million, or imprisonment of that particular individual that failed to comply. And the POPIA Act says 20 million euros, which can be levied as a percentage of global annual revenue for larger organizations, up to 4%. Considers imprisonment to be a matter of the member state. So that particular member state, of the EU, they'll then make a particular decision at that particular time, depending on what the sanction is. And then I think you see there the data protection officers. In POPIA, it calls them an information officer. Like I said, this can be a CEO that can delegate his responsibility to a deputy information officers. But most importantly, you need to make sure that you are registered with the Information Regulator. And the GDPR requires the appointment of what we call a data protection officer. And it's written in Article 37 of the GDPR. So it's more or less similar terms that are used in different pieces of legislation. And this is just a continuation to see the difference between these two particular legislation. Shall we get worried about data protection? I think yes, and the reason I'm saying yes, it's because we have seen a lot of cybersecurity attacks that results into data breaches, especially in the recent past. 95% of nation states sponsored threat actors use phishing as the dominant tradecraft for major data exfiltration events, highlighting its effectiveness. And I think we continue to see every minute, every hour, every day, one way or the other, you will receive some phishing SMS, some phishing email, and so forth. So 95% of these attacks, they come through what you call crafting very, very sophisticated phishing, different forms of phishing attacks. So according to Sabric, South Africa loses about 157 million annually because of what you call cybersecurity attacks. If you were really to convert that into rands, I don't even know if you to check the rate of exchange, the dollar rand exchange today. So that's a massive lot of amounts that the country is losing per year. In August 2020, news broke about Experian, a consumer business and credit information service agency that suffered a massive data breach, where about approximately 24 million South African PII was then dumped in the public, or it was exposed, which really, for me, raises a big question, that really we should worry as South Africa when it comes to these data breaches. I think we have seen in 2020, in December, Absa was especially robbed. I specifically got a call, to inform me specifically as a customer. I'm not promoting Absa anyway. I just happened to be their mere customer. They had experienced as well a data breach that exposed approximately 200,000 customers that were leaked. The city of Joburg as well. I think in 2019, I think we'll all remember this is one of the biggest municipalities across Africa. They also experienced, some. I think this was a ransomware attack, but obviously threatening, to demand some Bitcoin, at that particular time. And obviously, some of these things. How it happens is that if you refuse to pay that particular ransom, they might eventually dump your records that they have stolen, in the public. So just to show that these are not only, it's not only a problem, these data breaches of South Africa, even Nigeria, in Ghana, you can see there that in Ghana, some university accommodation system as well, it was hacked. But essentially here, if I follow this story, is that eventually they did not disclose the data which they've stolen into the public. So it's essentially redirecting the students to log in to a different website as compared to the one that was set up by University of Ghana. In 2020, you can see there's also a reported a major attack that exposed about 53,000 PII data, in Nigeria. So this is not only a problem of South Africa. So really, I think if we look at this state, we need to worry, as a country or even as a continent when it comes to data protection. So essentially here in this light, this is just a technical, representation of what we call a cyber kill chain, that can result into a data breach. But this example is for what you call a ransomware attack. So essentially, the first part it's the initial intrusion, where they use different techniques. It can be social engineering, it can be through a brute force attack, it can be exploiting software weaknesses. But essentially, if it is social engineering, there will be an email that they will craft, or an email that contains malware and so forth. And then they move to the next step, what you call gaining further access within your business. It can either through having escalated privileges within the network, within your Active Directory, or whatever system. And think about it, once you have AD access or administrative access, it can be at a database level, it can be at a server level. Once you have that admin access, you can definitely take control, and then you can start to decrypt the data, or to encrypt whatever the PII that you will have harvested within that network. You can steal business data, the trade secrets of a company, you can destroy backups and so forth. And then at the end of the day, you present what you call a ransom. You say you demand to be paid money. And if they don't pay that money, then that's when most of these cyber attackers, we see them doing what? Dumping the data that they've collected into the public, and then it results to a data breach. Now, what have we done as a country what sort of efforts did you come up with as a country, to fight all these data breaches that I've been talking about, to fight this cybercrime that I've referred to? So there's what we call a national cybersecurity policy framework, and I think most of my colleagues they read this piece of framework and they're sort of heartful with it. But essentially what it says is that as a country, we have got different government institutions that should have different mandates. For instance, in government, there's what we call the government CSIRT. So it's a computer security incident response team, with the responsibility of detecting and alerting the states if in an event where there is a massive cybersecurity attack. I will envision that as we move probably to the elections, you'll find that there might be a chance that we are going to see this thing happen. But the question will be, is the government CSIRT ready, to assist a government in terms of responding to those? Then we have the Cybersecurity Hub, which is an entity of the Department of Communications and Digital Technologies, that their responsibilities lies in assisting, the private sector, so in terms of establishing what we call sector CSIRT. So sector CSIRT, it's I think all of us, CEBRIC, that's a good example. So CEBRIC is one of the sector CSIRT that should eventually fit into the work that is done by the Cybersecurity Hub, but that's only for the banking sector. What about mining? What about retail? I'm aware about telecoms. They've recently set up their own sector CSIRT. But what about the other industries, the retail, mining, etc., etc.? So there's still a lot of work that I think the hub, in my view, needs to do to assist all these industries that they don't have this sector CSIRT, so that we can be able to fight the cybercrime at a national level. And then we've got the subs that are responsible for cybercrime, that gets reported, either by the citizens and whatnot. Then we've got the Cyber Command, which is the DoD and military veterans. So this is sort of a CERT that should be dedicated for looking at the military related cybersecurity incident. And that's the end of my talk. Thank you so much, Zama. I really appreciate it.
Thank you very much, Mr. Ngobeni, for a great presentation. There you have it, ladies and gentlemen. Mr. Ngobeni, while we're waiting for questions from the attendees, I have one question for you, just a matter of clarity, if you can clarify for us. From your presentation, you mentioned that other African countries, they don't have enough regulations with regards to data security or protection. I wanted to know, according to you, how are they affected by our own regulations like POPIA and the European GDPR that you mentioned? Are they affected at all? And when processing our information as the owners of the regulation?
Okay, thank you. That's a very profound question, Zama. So I think they will really be in danger when it comes to GDPR if they are doing business. Let's say Angola is doing business with the Europeans, and within that particular business, there is some involvement of personal information, and the GDPR calls it PII. So if there is that instance, obviously they need to make sure that they will have one way or the other to comply or to implement some security safeguards to ensure that the PII of the people that they do business with in other countries are sort of protected. And even during the time of audit, if they claim that they have got correct security controls to prove that, they will need to show so, right? And if it happens that there's a data breach, obviously the Europeans, or according to the GDR, they can come and impose that sanction by that particular country failing to comply to that particular legislation. But when it comes to the POPIA Act, so the jurisdiction of the POPIA Act is only within, it's applicable in South Africa. It does not say that a person in Botswana that does not comply. I mean, Botswana, like I showed on the map, they've got their own piece of legislation. So what we're seeing with most of these countries in Africa is that, and if you scrutinize them into detail, you'll find that some of them, I know Zimbabwe as well, it's one of the good use case. They don't have a clear sort of regulations that talks about data protection or privacy, but you find some elements or pieces of data protection, either it's in their constitution or in their ECT Act and so forth. And that example applies to many countries in South Africa, in Africa.
Well, that is great. Thank you again very much for that. I see that we have gone far beyond our scheduled time for this presentation and for the lecture. Thank you again, Mr. Ngobeni, for gracing us with your presence and for your intellect. We will now close this event for today. But before we close, please join us again next week. We will be talking about video intelligence or cyber intelligence when it comes to videos, and we'll be exploring on the unrests that we had in the previous months. And then don't forget to follow us, and if you missed this presentation, you'll find it on our social media. Our website is mosesgodane.com, and our social media will find us at Moses Godane Institute. So we look forward to having you next time. Thank you very much. I'm Zama Dlamini.
Thank you. Bye.